Appearances, please. Appearances?
Yes, my lord. With humility and respect to my lord, M.M. Walid.
Yes. Your appearance is for who?
My humble appearance.
You're for the claimants or the defendants?
Defendant, your worship. Your, my lord.
Yeah, okay. Do you have any representation for the claimants? Okay. Judgment.
As the court, please.
The claimants commence the instant action by the complaint and statement of facts filed on the 3rd of November 2017, wherein the claim against the defendants jointly and severally, the reliefs set out as follows. The reliefs, 5 reliefs and an alternative relief as stated on the face of the judgment. I will skip all this to save the time of the court.
As the court pleases, my lord.
Briefly stated, the claimant's case is that the defendants did not comply with the procedure for the dismissal of the appointment and thereby contend that their dismissal was unlawful. The defendants joined issues with the claimant by their joint statement of defense filed on the 20th of November 2017. Essentially, the defendant's defense is that the claimants were investigated for several allegations of serious or gross misconduct, and they were dismissed in accordance to the terms of their employment. The claimants did not file or reply to the defendant's statement of defense. At the plenary trial, the claimants testified in person, respectively as CW1, CW2, and CW3 in support of their case. They adopted their respective statements on oath as their evidence in chief and tendered a total of 5 sets of documents in evidence to further support their case. At the conclusion of the evidence in chief, they were subjected to cross-examination by the defendant's learned counsel. The defendants called a sole witness by name Mohammed Sani Suleiman, the company secretary or legal advisor. He equally adopted a statement on oath and tendered 16 sets of documents as exhibits. The defendant's witness was also subjected to cross-examination by the claimant's learned counsel. At the close of plenary trial, parties filed and exchanged their written final addresses as prescribed by provisions of Order 45 of the rules of this court. In the final address deemed properly filed on the 18th of January 2022, learned counsel for the defendants, A.Y. Abdulkadir Esquire, raised the sole issue as having a reason for determination in the suit, that is, whether having regards to the pleadings and evidence adduced before this honorable court, the claimants have proved their case on the balance of probabilities of preponderance of evidence to entitle them to grant of the relief sought. In the final address filed on behalf of the claimants, also deemed properly filed on the 18th of January 2022, claimants learned counsel N.S. Dantala Esquire formulated 3 issues as arising for determination in the suit, namely, whether the claimants have established the case against the defendants on the balance of probability to warrant the grant of all the relief sought by them. 2, whether the evidence of GW1 can stand and enough for this honorable court to refuse the claimant's claims. And 3, whether the claimant's wrongful dismissal is in accordance with Exhibit D8. I have painstakingly examined the totality of the pleadings filed by both parties in contention, the relief sought, the totality of the admissible and relevant evidence adduced at the trial, and the written addresses and oral submission of learned gentlemen for the two parties. And my view is that two issues call for determination in the suit without prejudice to other issues formulated for determination by respective learned counsel. I shall proceed to determine the suit on the basis of the issues set out as follows. 1, whether or not the claimants have established their claims for the award of declaratory relief and other relief sought. 2, upon resolution of issue 1 above, whether the suffered any loss or damage for which they are thereby entitled to be awarded general damages as claimed. In determining those issues, I had also carefully considered the totality of the written submissions canvassed in the written final addresses, and the court shall endeavor to make specific reference to arguments canvassed by respective learned counsel in their final submissions, as it is considered needful in the course of those judgments. Now, the case of the claimants is that each of them was an employee of the first defendant, and that they were employed at different dates and on different cadres. According to CW1 and CW2, their job descriptions included collection of revenue or at the Abubakar Gumi Central Market for the defendant and remitting the proceeds to the first defendant. CW1 and CW2 testified that sometime in 2010, one Malam Idris Sahid, the chief accountant of the defendant, verbally accused them of shortfall of the sum of 400,000 naira in their remittances to the first defendant, and that while the said sum was being deducted from their salaries, verbal accusation of shortfall of unspecified amounts was again leveled against them. They alleged that they were subjected to forced deduction of unspecified amounts until 2014, when the deductions were stopped by the intervention of Executive Secretary of the first defendant, one Yaya Tanko. CW1 and CW2 testified that in spite of the intervention of the said Executive Secretary, they were issued with letters of dismissal on the 18th of January 2016. The testimony of CW3 is that sometime in 2010, he sought and obtained the approval of the defendant for the repair of a Tiger generator set, and the money was also disbursed by the defendant for its repair. According to CW3, an incident occurred at the workshop where the generator set was being repaired, and all efforts to locate the whereabouts of the owner of the workshop proved abortive. CW3 further testified that he made a payment of 10,000 naira for the missing generator, that a committee was constituted in 2015 by the defendants to investigate the missing generator, but that he was not invited to defend himself before he was subsequently issued with a letter of dismissal on 21st of December 2015. The claimants also testified that they have suffered financial hardship due to the dismissal of their appointment, and the efforts they made to appeal for their reinstatement through the State House of Assembly and their solicitors have proved abortive. The claimants tendered in evidence the following documents to further support their case, namely, letters of dismissal admitted in evidence as Exhibit C1, C1A, and C1B, and solicitors' letters demanding restatement of the claimants admitted in evidence as Exhibit C2 and C3. Under cross-examination by the defendants' learned counsel, the claimants confirmed, upon being showed the letters of dismissal, that they were dismissed for gross misconduct. The claimants, still under cross-examination by the defendants' learned counsel, admitted that their employment is regulated by the terms and conditions, and they also confirmed that gross misconduct is a ground for dismissal in the terms and conditions of the employment. Isaac, I can hear you from here. I had also examined the testimony of the witness fielded by the defendants. DW1 testified that there were allegations of gross misconduct against the claimants at various times in the course of their employment with the first defendant. On the allegations of non-remittance of monies collected by first and second claimants, DW1 testified that they appeared before a four-man committee constituted by the defendants to investigate the allegation, that they both admitted that monies they collected were not remitted into the first defendant's account, and that they made undertaking to remit the money but have refused to pay the money. The further testimony of DW1 is that without the approval of the defendant, CW3 took the first defendant's generator set and has since refused to return it. That CW3 appeared before a four-man committee constituted to investigate the allegation of missing generator, that he admitted he took the generator for servicing, and his claim that the generator was being serviced was further investigated and found to be false. DW1 denied that a sum of 10,000 naira was paid by CW3 for the generating set. DW1 testified further that warning letters, queries, and letters of suspension were issued at various times to the claimant for different misconducts, and that they were subsequently dismissed. The following documents were admitted in evidence to further buttress the case of the defense. On letters of offer of the first and third claimants as Exhibit D1 and D2, queries issued on first claimant as Exhibit D2 and D2A, letters of suspension issued on the first claimant as Exhibit D3, queries issued on the third claimant as Exhibit D4, D4A, D4B, D4C, D4D, and D4E, letter of warning issued on the third claimant as Exhibit D5, letter of suspension issued on the third claimant as Exhibit D6, letter of dismissal of third claimant as Exhibit D7, and staff condition of service as Exhibit D8. DW1's testimony on the cross-examination is that his depositions are based on facts he garnered from the claimant's record with the first defendants. I shall now deal with the preliminary issues raised in the written addresses. The claimant's contention is that their employment with the first defendant enjoyed statutory flavor, and that they were entitled to a right of fair hearing before their employment could be terminated. Learned Claimant's Counsel had also argued in his written address that the claimant's employment with the first defendant is statutory employment. However, the claimant's averment in paragraph 4 of the statement of facts that the first defendant is a limited liability company was admitted in paragraph 1 of the statement of defense. In other words, parties are not in contention that the first defendant is a limited liability company registered under the Companies and Allied Matters Act. The Supreme Court has stated and restated that the two vital elements that must coexist before a contract of employment can be said to have statutory flavor, namely, 1, employer must be a body set up by the Constitution or statute, and 2, the statute or regulation made pursuant to the Constitution or principal statute or law must make provision regulating the employment of the staff of the category of the employee concerned, especially in matter of discipline. See, in this regard, the cases of PHCN versus Ofuelo, Comptroller General of Customs versus Busel, Kwara State Judicial Service Commission versus Tolani, Shuaib and others versus MBC PLC, that is Coca-Cola, citations also applied. It was an agreed fact between the parties that the first defendant in the instant case is not a company set up either by the Constitution of Federal Republic of Nigeria or by a statute. The evidence of claimants did not show that their employment had statutory flavor, which only arises where the procedure for the employment of the servant and his removal, therefrom, are governed by statute. The entire case of the claimants was predicated on misconceptions of the law regulating the relationship between employers and employees. Their claims were based on a fiction. The point being made is that the claimant's employment with a private limited liability company cannot be statutory employment. In other words, the employment of the claimant did not enjoy statutory flavor, and I so hold. I now go to the contention of the Learned Claimants Council that the testimony of DW1 amounts to hearsay evidence and therefore inadmissible. Section 126 of the Evidence Act 2011 states that oral evidence shall in all cases, whatever, be direct, and if it refers to a fact that could be seen, it must be the evidence of the witness who says he saw that fact. If it is a fact that can be heard, it must be the evidence of the witness who says he heard that fact. If it is a fact that can be perceived, it must be the evidence of the witness who says he perceived that fact by that sense or in that manner. And if it refers to an opinion, it must be the evidence of the person who holds the opinion. Hence, hearsay evidence is defined as a species of testimony given by a witness who relates not what he knows personally, but what others have told him or what he has heard said by others. It is evidence which does not derive its value solely from the credit given to the witness himself, but which rests also in part on the veracity and competence of some other person. See the case of Onovo versus Mba, 2014 Nigeria Weekly Law Report, part 1427 at 391. It must, however, be understood that it is not every evidence of what others told him which is related by a witness that qualifies as hearsay evidence. It is hearsay and inadmissible when the object of the evidence is to establish the truth of what is contained in the statement, and it is not hearsay, and inadmissible when it is proposed to establish by evidence not the truth of the statement, but the form that it was made. See the cases of Arogundade versus the state and Mancha and others versus Emukwate, citation supplied. DW1's testimony on the cross-examination is that his facts as contained in his deposition was derived from the claimant's case files or records with the first defendant. The testimony of DW1 of the facts as contained in the claimant's case files or records cannot in the circumstances amount to hearsay, and I so hold. Now, I am not unmindful that the claimants have sought declaratory reliefs in the suit. The implication being that the burden for them to prove the allegation leveled against the defendants exceeds the regular burden provided in sections 131 and 132 of the Evidence Act 2011. The settled position of the law from time immemorial is that even though the power to make a binding declaration of rights is discretionary in nature, a court would only grant declaratory relief sought in an action principally on the basis of the evidence adduced by the claimants without recourse to the evidence called by the defendants. The burden of proof on the claimants in establishing a declaratory relief to the satisfaction of the court is somewhat heavy, in the sense that such relief is not granted, even on the admission of the defendants, as the claimant must lead credible evidence in proof of the declaration of right he seeks from the court. An exception to the rule of pleadings that what has been admitted requires no further proof is that a declaratory relief cannot be granted without evidence, and it is not granted based merely on default of defense or an admission of the adverse party. See the authorities of Dumas Nigeria Limited versus Wakuba, Ogolo versus Ogolo, Ndayako versus Dantoro, and Olabenji versus Omakwewu. Citations all supplied. The general principles guiding the proof of a claim for termination or dismissal of employment have remained sacrosanct. For the claimant to succeed in his claim, he must prove that the defendant did not comply with the procedure stipulated by law for his removal. See Hamode versus Amudu versus Hamode, Angel Spinning and Dyeing Limited versus Hajar, citation supplied. Learned Claimants Counsel had argued that the claimants have shown by their pleadings and established in their evidence that the defendants have subjected them to illegal deduction from their monthly salaries and wrongfully dismissed them. As correctly submitted by Learned Defendants Counsel, to be entitled to the claims, claimants must show that their dismissal was not conducted in accordance with the laid down procedure and thereby wrongful. Learned Counsel for the submitted that the claimants must prove their case on the strength of their case and not on the weakness of the defendant's case, and further submitted that the claimants have failed to prove the allegation of wrongful dismissal of their employment against the defendants. Learned Counsel cited the cases of Adeton Oladeji versus MB PLC and Sankey versus Onashifike, citation supplied in support of his submission. As I had earlier restated in labor law, to be entitled to the declaration and relief sought, the claimants must place before this honorable court the terms and conditions of the contract of employment and prove in what manner the said terms were breached by the defendants. The claimants averred that deductions were made monthly from their salaries of CW1 and CW2 for 18 months from September 2012 to May 2014, that the third claimant got approval to repair a generator set, that the third claimant paid the sum of 10,000 naira, and letters were written to the defendants to appeal for their reinstatement. However, these were mere allegations that were not proved. Indeed, none of the exhibits tendered by the claimants to establish evidence of the several allegations made against the defendants. The terms and conditions of the contracts of employment were not placed before the court, and they certainly did not prove breach of terms by the defendants. CW1, CW2, and CW3, while testifying under cross-examination, admitted as follows. CW1, I quote, "It is true that we have terms and conditions of employment," end of quote. CW2, I quote, "Paragraph 2 of the letter of dismissal states misconduct, which is a ground for dismissal of appointment, as stated in the terms and conditions of employment," end of quote. CW3, I quote, "It is true, it is stated in defendant's condition of service that any person who causes loss to the defendant's property can be dismissed," end of quote. The law is very trite to the effect that any party who desires a court to give judgment as regards any legal right or liability dependent upon the alleged existence of facts must prove that those facts do actually exist. See Section 131 Evidence Act, Supra. See also Okoye versus Nwako and UIC Limited versus Amont Nigeria, citation supplied. Defendants tendered in evidence Exhibit D1 and D1A, letters of offer of appointment of CW1 and CW3, and Exhibit D8, the first defendant's staff conditions of service to buttress the defense. I should restate the settled position of law that the duty to prove the wrongfulness or nullity of the summary dismissal rests with the claimant, not the defendant. See Zidel versus RSCSC, Morofolu versus Kwara Tech, Ninji versus FBN PLC, and Cato versus CBN, citation also applied. As such, even if the defendant tendered Exhibit D8, the staff conditions and scheme of service, the onus to discharge the burden of proving the wrongful dismissal of their employment still rests on the claimants and not the defendants. I had undertaken a careful review of Exhibit D1 and D1A, the letters of appointment of the claimants. Paragraph 4E thereof states, I quote, "You should, however, note that in the event of any serious misconduct or gross negligence exhibited by you, such an action will earn a summary dismissal, thereby forfeiting any benefits accrued in your favor during your tenure." End of quote. It is stated in section 10(5)A of Exhibit D8 as follows, I quote, "A staff may be summarily dismissed of his appointment on the grounds of gross misconduct, which makes his continued employment prejudicial to the proper working of the company." End of quote. The admissible evidence of record in Exhibit C1, C1A, C1B, the claimant's letter of dismissal, is that the claimants were dismissed for gross misconduct. I fully agree with the submission of the learned counsel for the defendants that the claimants have not discharged the burden of proof on the crucial issue of wrongful dismissal of their employment by the defendants. This is fatal to their claims for reinstatement and damages. That's been the case. It becomes apparent that the entire exercise and proceedings become futile. In the circumstances, without any further ado, my decision is that the issues set out are resolved against the claimants. This action is lacking in merit and substance. It shall be and is hereby accordingly dismissed. Parties shall bear their respective costs.
As the court, please.
Yes, that is the decision of the court.
As the court, please. Yes, my lord. We are most grateful for the well-determined judgment. We are most grateful, my lord. Thank you.
We are sorry, my lord. We
for the claimant, who is appearing for the claimant? I didn't get your name, sir.
Due to network problem, apologies for coming.
Yeah, I heard you, but what's the name, sir?
A Aminu Esquire, my lord. A Aminu.
A Aminu
Esquire, yes, my lord.
For the claimant.
For the claimant, my lord.
Okay, so we found ourselves in this situation in this country, so we had to devise this means. The copy of the judgments will be sent to the division so you can obtain it for whatever reason that you want it for. So you can apply by the close, by the end or early next week so that we can give them time to be able to print it out or whatever. Thank you. Yes, the next case, please.
Case number 2, NICN/KD/04/2016. between Mr. Marshall Gawon and 1. Alizala Printing and Publishing Limited, and 2. Mr. Ahmed Akchet Hussein. My Lord, party is absent.
Yes, appearances, please.
With profound humility to my Lord, L.M. Shao. My appearance is for the claimant.
Yes.
Your Lordship, my name is A.A. Lanlege.
Sorry, A.A. Lanlege for who? Sorry, there's a feedback, so I cannot hear you properly. Whose brief are you holding? Okay. Yes, Ms. Chow.
Yes, my Lord. The matter comes up today for adoption of final written address.
Yes.
Subject to the court's convenience, we are ready.
You are ready, but you have
However,
a pending
my
motion.
Lord, we have a motion on notice.
Yes. Where was it filed?
Extension of time.
Where was it filed?
It was filed on the 22nd day of March 2022, my Lord.
Okay. Same has been served on the defendant.
Yes, Your Lordship, we have no objection to the application.
Grant what? Come and sit. Come and sit now.
Can you mute your phone, your device, please?
You must not be in black and white. We have done our case.
Mr. Wali?
Yes, my lord.
Can you mute your phone, your device, please?
Yes, my lord.
Yes, Ms. Chow.
Yes, my Lord, in light of the above, move in. Will there be no objection to the grant of the application? We humbly move in terms of the motion, my Lord.
Court's application granted. Time is hereby enlarged within which the claimants may file the written address. The already filed and served written address is deemed as properly filed and served.
I second this.
Yes.
My Lord, we have the claimant's written address.
Are you the one adopting first or the defendants? Who closed the case?
The defendant, I'm sorry, ma'am.
Do you wish to file a reply?
She didn't get you.
I didn't hear you. Do you wish to file a reply?
Yes, my lord.
Yes, we intend to file a reply.
Yes, my lord.
Okay, in the circumstance, I'll give you another date for adoption.
As the corporate.
Please.
28th of June, 28th of June.
It is convenient.
Ms.
It's
Charles, I hope
convenient.
it's convenient.
Convenient, my lord.
Court case is adjourned to the 28th of June, 2022 for adoption.
As the
As
corporate.
always.
Okay, so that's the end of the cases for today.
Yes, my lord.
The court will rise, please.